And with that, I will call the case in re Theresa Brennan. Mr. Kolenda, I believe you will address us first. You have 30 minutes. You can reserve some portion of that if you like.
Yeah. As the court has just indicated, I'm Dennis Kolenda from the firm of Dickinson Wright, and I'm here this morning on behalf of Judge Theresa Brennan. And yes, I'd like to reserve 5 minutes for rebuttal, just in case. Your Honors, this case is now, and those are important words, is now a tale of unrequited desire. And I didn't just admit what several people in the courtroom think I probably did. The desire here is not hormonal, it's ego, and it was not a desire by Judge Brennan for Sergeant Furlong or the other way around, but by the Judicial Tenure Commission, and the unrequited nature of the desire is that things didn't develop as the Tenure Commission thought they would. They're disappointed, not surprisingly, and they can't give up on what they thought was going to happen, but what has not been proven to have happened. Now that happens. Every prosecutor thinks he's got a winner, and probably most of them still think they do after the case is over with and the verdict of not guilty has been returned. Same with a litigator. They think they have a verdict, even a winner, even after the jury rules against them. But the fact that it's hard to acknowledge that things just didn't pan out the way you thought they would doesn't change the fact that they didn't pan out. And what it means is that it's this court that has to tell people, we looked at the record too, and it just isn't there. What you thought was there, what you still think was there, is not there when the record is looked at carefully. What am I talking about disappointments? Well, let's start with the 800-pound gorilla in the room. The belief at the beginning of this case that they really had the goods on Judge Brennan with regard to a romantic relationship with Detective Sergeant Furlong, going back at least as to 2007, and according to the master, reaching its zenith. He used the word its hottest, and I think we all know what that means. In late 2012 or 2013, just at the time that the Kowalski case was about to begin. But there was no romance in 2007 or through 2012 or frankly even into 2013 when it doesn't matter anymore because the Kowalski case was over with in March of 2013. There was testimony that there was a kiss in 2007 and that kiss indicated that there was an ongoing intense romance. Why? Because Judge Brennan didn't slap the guy or knee him in the groin or do something of that sort. Well, we all know that just because somebody doesn't immediately protest or doesn't walk away or even continues a relationship with someone, and this one was broken off for a while, that they are indicating that things were consensual. And if the kiss was an unwanted advance, which it was, and that testimony comes from the witness who brought us the kiss in the first place, it's not romantic. She's the one who said it startled the judge, it flabbergasted the judge, and she was upset by it and tried to figure out, what to do afterwards and whether she should cut off the relationship, and did in fact cut it off for a while. But the reality is, and everyone concedes, there wasn't any romance in 2007 or thereafter. We know that because, according to the JTC's own witnesses, Judge Brennan was trying to fix up Mr. Furlong with her sister and with another friend during this period of time. I suppose you can be madly in love with someone and trying to do that, but it sure doesn't happen, very often. It indicates that there just was not a romantic.
Counsel, good morning. If you could help me,
Yeah.
Usually when you get a brief, there's kind of an if-then, right? So one of the things that I would like you to kind of touch upon is, assuming if the court were to uphold the special master's finding, can you explain to us kind of what your viewpoint would be as to the penalties? Because there was no mention in your brief as to like an if-then. If the court were to uphold the special master's finding, then what would what is your position as it pertains to the penalty phase, if we were to uphold what the special master found?
Well, I struggled with that, Your Honor, and I'll answer your question and tell you why I didn't answer it beforehand. As I'm going through this, and hope I can finish explaining, I think that there wasn't what happened in any respect, certainly in no significant respect, and therefore there either should be no penalty or very little penalty. The big items, the so-called affair, just didn't exist. The relationship with Miss Polish didn't exist, and I'll explain that in a moment. Some of these other things just didn't exist. So to say, well, they didn't exist, and the record shows they didn't exist, but in case they did exist, here's the penalty, is, I think, a waste of words. But to answer your question, let's go back to Charnosky. It's the one time we had a judge who was actually having a sexual affair with someone before her, a lawyer. She was actually making decisions to the benefit of that lawyer during the affair. She was, first of all, appointing him to numerous cases, 50-some, as I recall, for which he got paid several $1,000s, not a huge amount per case, but not an insignificant amount either. And he had tried a case in front of her, a bench trial, where she sat as much in judgment as the judge is going to sit in judgment of a person, short of it being the litigant themselves, with the guy she was sleeping with. And this court suspended her. They didn't remove her from the bench, they suspended her. And in the Brown case, the court said nothing is more important than the court be consistent, and that like behavior be treated similarly and dissimilar behavior be treated differently.
So, counsel, I take your answer to Justice Bernstein to be you don't believe any of the misconduct alleged has been established, and therefore it would be it wouldn't make sense for you to engage the Brown factors in the event we disagree. So just help me think about what that means just as a matter of preservation. Does it mean, therefore, you've waived any ability to weigh in on what if we were to disagree with you on some of the counts or all of the counts, and we haven't decided that yet, that's why we're here, but if we were to, and you haven't presented any argument about the appropriate sanction as to any of the counts or all of the counts, do we now consider that waived, and we just have to apply the sanction the Tenure Commission has requested?
That's a most interesting question, Your Honor, because of the nature of these proceedings. We bandy around about the word de novo, but we don't give a lot of attention to what it means. Well, de novo means all over again, from the very beginning, independently.
I agree.
And so I really question whether the concept of preservation makes much sense when it's de novo review. But, to be honest with you, I think I'm going to mention a couple cases where maybe there was a little, and I don't think there was, but maybe a little, misconduct. And a little misconduct ought to be dealt with in less than a hanging. And, beyond that, I don't think we can say, well, we can do whatever we want because we didn't order otherwise. All I'm going to say is you've got to make the punishment fit the crime, and I don't think there were the crimes here, or at least, not very serious ones. and therefore the recommendation of a removal, from the bench is just way out of proportion, and obviously way out of proportion, and shouldn't be assessed.
Can you help me with a factual clarification, a record clarification? I appreciate that answer.
Yeah.
What does the record establish specifically on whether your client ever had an attorney-client relationship with Attorney Polish? Is that how you pronounce the name?
There was no evidence that they did. There was some testimony that at one point in time, years ago, and I'm talking 15 or so years ago, the judge mentioned to Ms. Polish that she was having trouble with a workman at the house doing something, and Ms. Polish says, well, make sure you keep your receipts or something like that. She didn't consult with her. She didn't ask her for advice. She got that very generic response, but that was it. The attorney-client relationship was with the judge's husband. He owned 2 businesses. Ms. Polish represented those businesses, and therefore there was a relationship there, and the master found, well, that still affected the judge because obviously she'd had the benefit of the income from those businesses, and therefore she was tied into that, which is completely contrary to at least the point I think made by Justice Corrigan, that that's nowhere near enough to tie a spouse to the other spouse, especially in this day and age when, both spouses tend to be working and having income and sharing income. But that was it. This one, well, make sure you keep your receipts or something like that, but she never represented anyone. Nothing ever came of it, and it was Ms. Polish responding to a generic, I'm having trouble with this guy who's not getting his job done, not asking for any kind of relief. And we're going to talk about Ms. Polish. One thing to keep in mind is the JTC talks about this relationship they had. Oh, they went skiing 3 times with another group of ladies over 20 years. They belonged to the same book club. The book club went to each other's cottages, and they may have gone to each other's cottages once in a while. We can put all that aside because the JTC itself says that the misconduct was Judge Brennan not recusing herself or not disclosing so people could move to recuse themselves, a relationship she had while 5 cases were pending in front of her. Those cases were pending in 2014 to 2016. The testimony is uncontradicted that in 2014, 15, and 16, Judge Brennan and Ms. Polish were estranged to the point that they weren't talking to one another, that their relationship was, they agreed, Ms. Polish agreed, was dead, and that they had nothing to do with each other during that 2-year period of time. Now, does the fact that someone, let's assume they had a relationship, had one that they no longer have, is now also a disqualifying consideration? Certainly not for any of the people on the opposite side of Ms. Polish. If you want to make an argument and no one's making it, well, her clients needed to know that maybe there was some bad blood and didn't want to be appearing in front of the judge, but nobody says that that should have been disclosed, and that was up to Ms. Polish to disclose. So there was no attorney-client relationship, period, with the judge. There was no relationship at all during the 2 years, 2.5 years that they were estranged when these cases were in front of her. One of the witnesses says, well, friendships come and go. Yes, that's true, but that doesn't eliminate the problem. That just says we have to decide, had it come or had it gone? And it was gone. To return to my first point, just to finish it up, now that, so it starts off with a finding that there was this hot romance right before the trial, except there's absolutely no evidence of that. The only evidence is that a romance started a year later. The kiss, the witness who saw it says, well, it startled her, it offended her, and it was obviously not the beginning of any kind of a relationship. Well, if that's what the observer who brought the kiss to people's attention is saying to describe it, why are we even considering that, well, there really was something else? There can be unspoken things going on, but unspoken things aren't proof. You got to have proof from somebody. And the witness who brought the kiss to the master's attention.
Counsel, Could you explain, I think, my understanding is the commission found it unnecessary to determine whether or not it was romantic, but found that other aspects of the relationship still required disclosure. So could you focus on, let's assume for the sake, as the commission said that they did, that
Well-
we don't need to determine that or wade into that issue, but there are other aspects of a relationship that should have at a minimum been disclosed.
Well, first of all, yes, that's what the commission said, and then they unsaid it. Because in their brief to this court, and remember, the brief to this court is by the commission, no longer by the examiners in this so-called independent role of theirs, which I don't understand, but the rules, create it. The court, said that they then went on to say later on in this brief that she and the detective sergeant had the closest, most intimate, non-sexual relationship. That seems to be playing with words to avoid saying, well, there's really a problem here, but we can't use the word sexual because we stipulated that there wasn't anything sexual.
Counsel, could you address talking about the case?
Am I talking about what, Your Honor?
Talking about the case that they were deciding, talking about the case that he was testifying in?
Kowalski?
Yeah, if you could if you could just explain to us, conceptually what was happening with that, your position on that.
First of all, there's no evidence, none, that they talked about the case. The claim that she had expressed some kind of an opinion had been passed on to her. Well, she had been questioned by her secretary. This was before the case was assigned to her. When the detective sergeant was someone she'd meet with others for a drink after work, have lunch with others, always with others for a drink. And she told her secretary, Detective Sergeant Furlong, says, don't worry about it. The case wasn't assigned to her at the time. Don't worry about it. He's guilty. Your Honor, I was a criminal defense lawyer before I was a circuit judge for 20 years. I don't have enough appendages to count the number of times a police officer told me, oh yeah, somebody's guilty. It rolls off your back. It's not, I don't think it's a basis for saying that because the judge heard it and told someone before the case was even assigned to her that, that reflects some kind of a prejudgment. We had a prejudgment in this case. That was the JTC telling this court that Judge Brennan was guilty, to put it bluntly, guilty as hell, of tampering with evidence and perjury.
So if you could just clarify for me, so what exactly is the position that you're taking on that? In terms of the discussion about the case, about Kowalski as it pertains, you're saying it was just a non-issue? I'm just trying to understand specifically what you're arguing.
It's a non-issue. There could be other circumstances when it's an issue. But when your secretary says, I'm typing up transcripts and I'm not sure this guy's guilty, and the judge says, well, the detective sergeant tells me he is, and that's the end of the conversation, and it's another year before the case is assigned to her, with all due respect, what's the big deal? It's just idle, conversation at that particular point. Not something, if you're saying it in the middle of the trial after the proofs have been presented, and then you, by the way, raise all kinds of questions about, judges discussing things with their staffs and whatever. But the simple thing is when it occurred, which was pre-assignment of the case, makes it no significant deal in this particular case.
And can you tell us your position about the phone?
The phones?
With the text messages and deleting the messages?
Okay, well, there were, according to the records, 1,500 phone calls over multiple years and 400 texts over multiple years. That sounds like a lot of calls, except in the day and age of cell phones and texts. I have no idea whether it is, and nobody bothered to present a witness to say that that is or is not a lot. But what we do know, in another case from this court, the Simpson case, the court pointed out that Judge Simpson had contacted by phone, text, or phone calls a clerk in his office, an intern in his office, several thousand times over 5 months. that was far, far more than we're talking about here.
Do you find a distinction between phone calls and texts that occurred during the trial and between judgment and sentence
No,
with this
not without
particular
knowing what was
witness?
said. And nobody produced any evidence of what was said. We've got all these forensic experts we're talking about. We've got phones that, by the way, were there that nobody asked to see, her replacement phone. You know, all this time, they've never asked the phone to which she transferred all of this data. Nobody's ever asked, can we see it? They're complaining, well, we look at the old phone and the old phone doesn't have it anymore, but we can see transferring it to another phone is not a big deal. Why didn't somebody, they knew about this back at January 2016 at least. That's when the transfers had happened, and that's when the questions in the deposition occurred. And to this date, nobody's looked at the phone. So why should we can't be speculating as to what their subjects were and what the subject of the text were. Judge Brennan testified for 3 days. Nobody asked her.
Well, without really understanding or being able to, as you suggest, understand what those text messages say, I think the implication, isn't it, that it's evidence of a relationship that at a minimum needed to be disclosed if you are engaging in phone calls and texts, regardless, even if it's not necessarily about the case. I mean, doesn't that support the assumption or the finding that they had a very close personal relationship that, again, at a minimum should have been disclosed to the parties?
It discloses that, with all due respect, Your Honor, it establishes that they were exchanging phone calls and texts. How close was it? We don't know. I mean, sure, it sounds like a lot. It sounds like a lot. But in these halls, we deal with proof. And all we've got is someone saying, well, there was a lot of calls. Was it? Over several years, was it a lot of calls? Somebody from the phone industry could have told us. Someone who understood texting practices could have told us. I dare say, if we're going to engage in speculation, that there are a lot of people, a lot of these young people in the courtroom behind us who do a lot of texts per day. And if you added them up, they'd add up to a lot more than we're having here. And it's important to note, especially the number of phone calls, because we got comparisons for those. Mm-hmm. The number of times that Judge Brennan and Mr. Furlong exchanged phone calls was fewer than the number of times she exchanged calls with her sister, and almost exactly the same number of times she exchanged calls with Miss Ryan, who was the assistant prosecutor, who was one of the key witnesses for the JTC, and who brought a lot of this to people's attention. Miss Ryan was an assistant prosecutor. She was talking with the judge just as often as Mr. Furlong. And nobody was suggesting that, well, she should have disqualified herself, that Miss Ryan should not have been allowed to appear in front of her without a disclosure. What does that tell you? Maybe nothing, but nothing is significant. It tells you that it didn't hit anybody as significant, that Miss Ryan, who was appearing as the prosecutor assigned to Judge Brennan, was on the phone with her just as much as Mr. Ryan, and it's no big deal, no matter of concern with regard to Miss Ryan, but it is with regard.
Is there a difference between it being a prosecutor assigned to that judge, meaning a counsel in her chamber, in her courtroom, as opposed to a witness in a case?
No, because what the witness was testifying, and the decisions were being made by the jury, not by the judge. He was on tape for them to watch. When I started practicing, you had to take the police officer's word that someone confessed in the first place. You had to take the police officer's word that he said whatever it was he said. You had to take the police officer's word that it was said in a way which was telling or not telling. You had to take the police officer's word that he didn't press people or ask follow-up questions or ask leading questions. Why? Because none of this stuff was recorded. In those days, the police officer was extremely important to establishing the particulars of a confession, frankly, the fact of a confession. These days, especially in this case, the defense attorney acknowledged everything. He didn't dispute anything. Everything was on tape. All it had to do was be played. And the judge sat there and watched like everybody else. And by the way, saying, well, you know, she made decisions about the confession back in 2009. First of all, the JTC now says we're not concerned about what was going on before 2013. So if, to answer Justice McCormick's question, we forfeited something by not pursuing a point. Haven't they forfeited the argument by conceding we're never concerned? Our complaint was never concerned about, you know, the phone calls and the contacts before 2013. One of the things that's always struck me about this case is, and that's why I think I made the decision, yeah, they decided, they meaning the JTC, they had the goods on the judge, and they're disappointed that the evidence didn't quite, turn out that way, is because there's just a lot of gaps in this record. And let's be blunt, it wasn't my job to fill in the gaps in the record. It was up to the JTC to at least make the effort to establish what the phone calls were about and what the texts were about. And if there was some kind of this hot relationship, to get something on the record besides a witness saying it wasn't the commencement of anything. And all we've got, for example, is the testimony from Detective Sergeant Furlong, who curiously was not called as a witness before the master. His divorce case deposition was just put in evidence. He said, we didn't have our first romantic kiss until 2014, which was a year after Kowalski, and we didn't start having sex with each other until after that. So we're talking about a year after the trial. So the reality is we got a lot of gaps in here as to how, other than our desire, the word I used at the beginning, the desire to say the judge did something wrong, where's the evidence, that she did? In terms of,
you're under 4 minutes. If you want to reserve time, I'm just.
Under the, I know, and that's.
You don't have to. It's up to you. I'm just giving you a.
Well, just say there's a lot that isn't part of this record, and Justice Bernstein was asking, well, what about other evidence? I think of their relationship. Well, there was the phone calls. As I said, the phone calls don't tell us much. They certainly are far fewer than were the problem, if it was a problem, in Simpson, and the Tenure Commission didn't even bother to claim that established an improper relationship, just that it wasn't a business relationship when they were talking on the phone, but they wouldn't go further than that. This court says, well, they're not claiming it, we're not going to find it, and in this particular case, there's a claim, but a claim of with no foundation to it, other than the desire that it prove something. So what are the other things? Well, at the invitation of Miss Ryan, the judge would go out with the group of people for a drink after work. Sergeant Furlong might be there, probably was there often, but so was Miss Ryan, so was Miss Morrison, so were federal prosecutors, so were state cops and local police officers. So is having a drink after work, even if you do it with some regularity with a whole bunch of other people, indicative of some kind of a unique personal relationship? No, it's indicative of the fact that this group of people are friends with each other. Yes, the people in this group had a meal together now and then, but even the JTC has to concede we have absolutely no evidence that they were ever seen together having a meal. And the testimony was, well, I'm going out to lunch with Sergeant Furlong. But the witnesses were saying, well, but that sometimes meant Sergeant Corriveau. They were the Bobbsey twins. They were usually together, so it was these two officers plus Judge Brennan. There were others as well at these particular things. Yes, he was a social guest in her house, according to Mr. Kaiser's letter. Sounds nefarious. He was there with 10 other people for a dinner. Judge Brennan liked to cook and liked to host dinners and would have them on occasion, and Sergeant Furlong was there for a couple of those. Yes, at one of those dinners, this infamous skinny dipping incident occurred, except Sergeant Furlong didn't participate. He wasn't even in the vicinity of the pool at the time. So somehow the fact that a bunch of middle-aged women are acting like teenage girls in the pool doing whatever they're doing by themselves to be said to indicate a romantic relationship between the sergeant and the judge when the sergeant was not in the pool and was not, according to the testimony, even in the vicinity of the pool. He was in the house somewhere, but if he doesn't participate, how can that be said to prove anything with regard to these people? Yes, the three of them, not two, the three of them, Judge Brennan, Sean Furlong, and Miss Ryan, went Christmas shopping 3 times. Well, the two ladies were doing that, and Miss Ryan, on her own, invited the sergeant to go along. He came along. Everyone had a good time. So for 2 more years, they went to lunch, did a little shopping, and then went home. I'm not sure it would have proven anything if it was the 2 of them, but it wasn't the 2 of them. We have to start recognizing here that a very special relationship, this
Counselor,
very special, intimate
conclude your time as well.
relationship was always with other people. Is
Thank you very much.
that kind of a relationship?
Thank you very much. I appreciate it. Mr. Helland.
Good morning, Your Honors. I'm Lynn Helland, together with Cass Swastek for the Judicial Tenure Commission. The commission found that Judge Brennan committed 7 separate species of misconduct. And I'm sure you're familiar with this. There's an extensive record that supports the commission's findings. We could, if we're also inclined, spend a long time talking about the individual bits of that evidence, the individual trees in that forest. Well, we've already given you an oversized brief about that, and really, I'm not sure it's a good use of your time to talk, at least for me to talk about those individual trees. What I would like to do is take a step back, look at the whole forest for a little bit, and kind of conceptualize what I think the evidence shows was going on here. The first thing I want to do is say that these 7 different types of misconduct pretty much fit into 3 what I think are kind of revealing categories. The first category is deceptions. Judge Brennan's false statements when she was on the bench, her false statements when she testified in other proceedings, and her false statements when she was answering the commission's questions, together with the deception of taking the data off her cell phone when that phone was subject to a motion to preserve the evidence on it. The second group consists of Judge Brennan abusing her power over attorneys, her power over court staff, and when she's abusing her power over her court staff, also using that abuse to get the court staff to do personal things for her. The third group consists of Judge Brennan's conflicts of interest. Those included both in her own divorce case, but also when she was presiding over 2 cases of people who were very close to her. Conceptually, most everything that the commission found Judge Brennan did fits into one of those 3 groups. But that grouping doesn't explain why she made so many false statements. It doesn't explain why she so abused her power over others. And it doesn't explain why she allowed herself to have such serious conflicts of interest and failed to disclose them. Well, just like there are, I think, 3 main categories of misconduct, I think there are 3 characteristics of Judge Brennan that resulted in that misconduct. First, she enjoyed the power of her position. There's nothing wrong with that. But she did not recognize any constraints on that power. Second thing is, she couldn't separate her judicial self from her personal self. And these 2 traits, I think, are why she didn't think it was necessary to so much as disclose her relationships with Sean Furlong or her best friend and husband's lawyer, Sherry Polish. It's why she didn't see any reason promptly to get off her own divorce case. It's why she felt free to delete that data from her cell phone, even though it was subject to that motion to preserve. It's why she treated her staff as vassals. It's why she could vent her spleen against court personnel and attorneys who had the misfortune to come before her. But the third troubling aspect of Judge Brennan's character, and I think this is key, and actually, whether he intended to or not, Mr. Kolenda alluded to it again during his argument, she never acknowledges any wrongdoing. except in the most inconsequential of ways. So whenever she has to confront the possibility that maybe she did something wrong, her default position is to conceal, to lie, to mislead. So she did that when she was asked during the Kowalski case about her relationship with Sean Furlong. She did it when she was asked during a court proceeding about whether Sherry Polesh had represented her husband and when she knew about that. She did it when she was asked why she didn't disqualify herself from her own divorce case. She did it when she was asked about deleting the data from her phone. She did it when she was asked about having her staff do campaign work and personal errands. You can spend all your free time looking over the extensive record, looking over Judge Brennan's various statements to the commission, reviewing Mr. Kolenda's arguments on her behalf, and you won't find her acknowledging that the commission's and the master's findings were even a little bit right. You can sometimes find places where she acknowledges perhaps an unintentional mistake, but that's as close as you're going to get. In Judge Brennan's view, she seems to be just a victim of forces that are out to get her. None of this is on her. I think that as a litigating posture, perhaps for a criminal defendant, it sometimes makes sense to maintain your innocence in the face of even overwhelming evidence. But for a judge to maintain her position of, hey, I did nothing wrong here, in the face of the record that's developed here, I think shows something else. I think it just shows a self-serving denial of a reality.
Counsel, good morning. I have a question, though. But that brings up a very interesting point, though. I mean, do you feel that that people should be penalized by putting on an intensive defense?
No, not at all. And I hope I didn't communicate that in any way. What I do say is you shouldn't deceive. Okay. What I do say is if the evidence, if there is very strong evidence supporting what the commission has found across the board, and all you say is there's nothing there,
I see.
You're not owning it. You're not owning what you did. That's what I'm trying to say. These three characteristics I talked about. The Judge Brennan doesn't recognize limits to her power. She can't separate her judicial self from her personal self, and she cannot acknowledge any kind of wrongdoing. Those three characteristics, I think, are why we're here. And it's why the commission was right to conclude at the end of everything that she needed to be removed from the judiciary.
Mr. Helland, could
Yes.
you address the recommendation for a conditional suspension and the authority that either the commission and or the court has to impose that?
When you say conditional, you mean keeping her from running in the future?
Correct, right.
This court did that in McCree, and ergo the authority, I believe, exists. I also think it exists as a practical matter. There would be two ways to approach it. Were the court only to remove Judge Brennan from her court, she could run again in 2020. That's when her term expires, which would mean that any removal would last only until then, were she to win. This court in McCree, the commission in this case, thought that's just too short a time under all the circumstances. Therefore, the commission relied on McCree to extend her removal. The other way to do it is to just have a suspension of 6 years or 8 years, or permanently some suspension like that. But I do believe the authority exists.
And
You indicated that that would prevent her from running again, but this court doesn't have the authority to do that, do we? We can remove her, and then if we were to do a conditional suspension, she could still run, and then that suspension would be put in place.
Correct. I mean, yes, I agree. Okay. Technically, she could run, but then not serve. And I'm sorry,
I was just going to, because in the Constitution of the what we may do as a court, which is censure, suspend with or without salary, retire or remove a judge. I'm wondering. I understand the point in McCree, but where does the conditional suspension arise through the Constitution?
I don't think there's anything in the Constitution that is inconsistent with future removal or suspension that goes on for longer than a judge's term. The Constitution just describes the different mechanisms available, but doesn't limit any of those mechanisms.
Okay.
There was one more sort of big picture thing I wanted to say about the evidence. As you know, if you've read the briefs and read the record, a lot of this forest of misconduct, a lot of the trees in it, have to do with false statements. And if you spend some time with the 3 written statements that Judge Brennan submitted to the commission, spend some time with what she has said in court as reflected in the record, spend some time with her testimony during the hearing, and then contrast all of that with the other evidence that's in the record, you'll see a couple of things. One thing you'll see is she often creates this very false picture with a bunch of very small lies, where each lie is like an individual pixel in the bigger picture that's a false picture, but it depends on the pixels that are in it. The other thing she does is that she misleads by saying something that has a kernel of truth to it, but then a twist, so that what she says creates, again, a very false impression of what actually happened. And those are my big picture thoughts about the record that's before you. Again, I don't think it's helpful for me to stand here and talk about trees that matter to me. I want to respond to 3 things that Mr. Kolenda said, and then what I really want to do is answer your questions. Mr. Kolenda now describes the kiss between Mr. Furlong and Judge Brennan as an assault. He says it was not romantic. Sean Ryan testified that what Judge Brennan told her, when Judge Brennan told her about it, was that in fact the kiss was romantic. It unnerved her, sure enough, but it was romantic. The court asked, I believe Justice McCormick, you asked about the period of the relationship, the representation between whether Sherry Plush represented Judge Brennan. There's no evidence that she actually represented Judge Brennan. In connection with Judge Brennan's divorce, Sherry Plush wrote a letter which strongly intimated or maybe said that she represented Judge Brennan in order to avoid having to testify in connection with the divorce. But there's no evidence that she actually did. But then Mr. Kolenda went on to say, actually, they were estranged during the period of the 5 cases when Judge Brennan might have had an obligation to disclose her relationship with Ms. Palash. First point about that, Ms. Palash was still representing Judge Brennan's husband. But the more important point is there are 10 cases, and the cases begin before any period of estrangement, continue after any period of estrangement, and in the middle of all that, Judge Brennan herself described Sherry Palash as her best friend. Mr. Kolenda, when asked about the phone calls, said that Judge Brennan talked as much to Sean Furlong as she did with Sean Ryan, who was the prosecutor in her court. Actually, Sean Ryan was only the prosecutor in her court in something like 2005 and 2006. The phone calls where we can say who Judge Brennan talked to and how much, those were for the 14 months preceding the Kowalski trial, so late 2011 through the end of 2012. During that period, Sean Ryan was just a friend, and the exhibit, I think it's 1-24, which demonstrates who Judge Brennan talked to, shows that she spent virtually as much time on the phone with Sean Furlong during that 14 months as she did with her sister. And those two are at the top. Sean Ryan is a little bit below. Is that a lot? Is it a few? Those are questions. Those are straw man questions. What matters is that in Judge Brennan's universe, she talked to Sean Furlong as much as she talked to anybody and couldn't resist talking to him during the Kowalski trial. Those are my corrections to what Mr. Kolenda had to say. Does the court have questions about any of the trees?
Go ahead.
Counsel, if I were to prioritize the number of charges that have been brought, how would you prioritize them?
That's actually kind of an interesting question. Different people have react to the charges in different ways. For me, the most serious charges are the pervasive lying. And I don't really, I think the lying should be viewed as a package. But whether you view it as a package or just look at individual lies, for me, the most serious misconduct is the lying. Somebody else might say, and other people do say, the most serious misconduct was her not getting herself off her own divorce case and then tampering with the cell phone after the motion to preserve evidence was filed. Other people say, and again, I've had conversations with folks who kick this around, other people say that the most serious thing is Judge Brennan failing to disclose her relationship with Sean Furlong in connection with a homicide trial and then concealing that relationship when it was brought out and thereby compromising the verdicts in that trial.
Would any one of these result in the type of penalty that you're asking for?
And that was going to be my next point. We don't have to choose which is the most serious because any one of them by itself would suffice to have her removed from the bench.
Counsel, can we talk, can you address the costs you have requested? If we agree with you that costs should be assessed, how do we determine why $35,000 is the correct amount?
There is an affidavit in the record.
It's not very specific about what.
We modeled it on earlier affidavits. We could certainly add specificity to it if that were important. But what we did, so the categories of expenses are listed on the affidavit. Yeah. We tracked those expenses and then put them together in that form. But that affidavit is what the record has at this point. It's uncontradicted and it may lack specificity, but more specificity could always be added.
I mean, historically, costs have been tied to false statements made by
That's correct.
The respondent.
Well, but not in the sense that this false statement costs so much money, and therefore there is a cost. The way it has worked is if there are false statements by a respondent, then the respondent is liable for costs, and the costs are all the costs.
Thank you.
But the court has historically not imposed all costs.
You will have the advantage of me there, Justice Zara. I know that in some cases the court has imposed costs. To be honest, I haven't parsed when the court has and has not. I know that in the Gorsica case, the court concluded there was no false statement or intent to mislead, and therefore there were no costs. But I'm just not. I just don't know. I could get back to you on that.
It's okay.
Okay.
Any further questions from the court?
If there are no other
Seeing
questions, then yeah, I don't want to waste your time. I just want to reiterate the point that there is an extensive record. The record supports the Commission's findings, the misconduct by this court's precedent. So if you analyze the three most serious types of misconduct, add the other misconduct, look at all of that through the prism of the court's precedents, really, Judge Brennan needs to be removed from the bench. That's the only reasonable conclusion. Thank you.
Thank you, Mr. Helland. The case will be submitted.